to the next motion, which is, this will be, I think, the state's motion, Ms. Drain Burdick's motion, to strike the defense witness list, which she has attached to her motion. And let me just turn it over to her. Go ahead, Ms. Drain Burdick.
Your Honor, this motion was actually filed in December, shortly after we received a witness list that had the names of 3 experts on it, and then just a reference to the state's witness list. Under the case law, that was improper, so I did file a motion to strike. On January 22nd, it was an amended defense witness list was faxed to me that appears to be legally sufficient, and so our motion is now moot.
All right, the motion to strike is moot. You now have one that's correct under the rules, and so there's nothing else that needs to be said there, which gets us to our final motion this morning. And then if we have a second, we can talk about perhaps a status date and see where we are. This would be the emergency motion to recuse filed by Ms. Bodden. Why don't you go ahead?
Yes, thank you, Your Honor.
And the
Good morning,
motion to recuse goes to the state attorney, correct? That's who you're trying to recuse.
Good morning, sir.
Good morning. Go ahead.
Your Honor has taken great pains to make sure that both the state and the people of the state of Florida who have a vested interest in this case, along with our client, Casey Anthony, who has obviously a vested interest, all rights are protected on both parts. Your Honor, as you know, has required Ms. Anthony to be here in court on the basis that should a conviction be obtained by the state, Your Honor did not want any appealable issues that were just flagged out there that could overturn such a conviction. Likewise, Your Honor, obviously has been and has the duty, and we trust, Your Honor, because you do wear the robes, to protect all of the interests of our client, Ms. Anthony, when it comes to the basic fundamental rights of the right to the fair trial and the right to representation of her Sixth Amendment right to counsel. Now, we have filed this motion asking, Your Honor, to ask the prosecutor to voluntarily recuse themselves or whatever persons in the office this may be applicable to because of an incident that arose that we became aware of. Again, as we become aware of many things in this case through the media. The other day there was a media report filed, and we put that in our papers, concerning the fact that at least one of the complaints before the board, the ethics board, was filed by someone, and we do not know who, because it's kind of like a Kafkaesque trial situation. Allegedly they were supposed to be anonymous, but apparently the agency responsible for that did confirm to the media that the state's attorney's office, someone, had filed a complaint against Mr. Baez, allegedly for the statements made against the state's prosecutor, Lawson Lamar. I would note today, for Your Honor, and I did confirm this myself last night with Professor Timothy Chinaris, C-H-I-N-A-R-I-S, who I believe Your Honor is aware of. Mr. Chinaris was the ethics director of the Florida Bar from 1989 to 1997, and he was a member and past chair of the Professional Ethics Committee of the Florida Bar for a period of time, and he was the attorney representing Mr. Baez in this matter. He did speak to Mr. Marvin, who, and Mr. Chinaris is available for Your Honor should you need a phoner later on to confirm this. He's on a plane from Alabama to Florida as we speak right now. What the board does is they can't release the name, but they did confirm, if you ask the question, was this filed by the state's attorney's office, they did confirm to Mr. Chinaris that the report that we allege in our papers was true, that someone from the state's attorney's office, again, we do not know who, did file this complaint against Mr. Baez. Now, what's troubling about this, Your Honor, and I know that there have been cases cited by the prosecution, but none of them are apposite here, because they don't apply to situations where there is a constitutional right of a right to not interfere with counsel under the Sixth Amendment. They apply to other things, such as should there be a witness in the office that may testify in a trial? Should there be a sitting judge in an area that may testify? But none of them in Florida have ever dealt with the issue of the right to counsel under the Sixth Amendment as applied through the Due Process Clause. And therefore there we have to look to federal law for that. And federal law is clear, Your Honor, that if there is a motive, and it goes to motive, and the problem Your Honor has right now, and that's why we ask for a hearing and more help from Your Honor, because you do wear the robes, that you have to find out who it is that filed and what was the motive behind it. And let me just say that we think we've made a prima facie case for Your Honor to do that, because the complaint that was confirmed by Mr. Chinaris that was filed about 15 days ago now. The allegation that apparently that it dealt with was the statements supposedly attributed to Mr. Baez about Lawson Lamar and re-election made by a third party. However, and what should also be clear from the record today, Your Honor, is on that day that occurred, there was a press conference by Mr. Baez, that is October 14th, 2008, where the following actual statement was made, and this was submitted to the bar. "I want to hear it straight from my mouth," Baez said. "These are my words. I understand that there is an election going on, and I understand that those days are numbered, and I understand that Casey Anthony is public enemy #1, and that the state's attorney's office and sheriff's department is under a great deal of pressure to close this case. I don't think Lawson Lamar, and I certainly hope that Lawson Lamar would not utilize a missing child to keep his job. So I'm not going to throw out any accusations. It's not coming from me." Right after that press conference, Mr. Baez called Ms. Drain Burdick. He actually called Mr. Lawson Lamar and asked to speak to him to say it wasn't me that said what that third party is saying. That call was refused. He then called Ms. Drain Burdick to say it wasn't me. Now, what's troubling about this is that if there is a reliable allegation of some misconduct, that should have been filed October 15th, October 16th, October 17th. I can go on and on, you get my drift. But it wasn't filed until after we started filing motions in this case, actually litigating pretty, to represent our client as best we can in this case. It wasn't filed too recently. If the prosecutor's papers say they, and I believe them, that none of the three there filed this complaint. I have no reason to disbelieve them. But what it doesn't say is that whether they have any knowledge about whether anybody else filed that complaint in that office. Your Honor has an obligation to make sure